Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
We are in the information age on Do You Know Your Value page. It's the content creator, the force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation as we proceed to give you what you need. I did notice that there's some continuing on from this is Creditors and Empire, continuing on. This will be part 4. But what I did notice is that there's some typographical errors. So you still need to do your own research, do your own due diligence to make sure all the information that you coming across is true and correct. The best way to do is to do your own. The best way to get a better understanding of anything that you read is to do your own research. Don't just take anything for face value. Not my word, not anyone else's word. Nothing you read, research it. That being said, we're going to begin now. It all has to do with trust. Everywhere you look, there are trusts. The straw man is a trust when it is named on a complaint, indictment, or traffic ticket. Sometimes it is a cesticate trust when it is the beneficiary of another trust. Sometimes it is the trustor or another trust. Sometimes it is a corporation sole. Sometimes it is a defendant. Sometimes it is a plaintiff. Sometimes it is a debtor. Sometimes it is a creditor. Sometimes it is a secured party. It is a very versatile vehicle or tool. There are always at least 3 parties to a trust. No one owns a trust on the private side, but on the public side, there's always a responsible party who is deemed to be the owner of the trust. This is a fallacy that is often used by the state in relation to trusts that have real property as the trust corpus. They always want to know who the owner of the trust is. A trust is just an agreement among 3 or more parties. The trustee holds the legal title to the trust corpus and the one deemed to be owner of the public trust. It is useless to argue if it's public property or is involved with Federal Reserve notes, it qualifies as a public trust. The beneficiary holds the equitable title to the trust corpus. The title is bifurcated. A trust, a legal entity created by a grantor for the benefit of designated beneficiaries under the laws of the state and the valid trust instrument. Indenture, the document which contains the terms and conditions which govern the conduct of the trustee and the right of the beneficiaries. Exchange, to part with, give, or transfer for an equivalent. Trustor, one who creates a trust, also called settlor. Settlor, the grantor or donor in a deed of settlement, also one who creates a trust. Trust corpus, trust property, the property which is the subject matter of the trust. The trust res. Creator, one who creates. Trustee, person holding property in trust, one who holds legal titles of property in trust for the benefit of another person, beneficiary, and who must carry out specific duties with regard to the property. Legal title, one which is complete and perfect so far as regards the apparent right of ownership and possession, but which carries no beneficial interest in the property, another person being equitably entitled thereto. Beneficiary, one who benefits from acts of another. Equitable title, a right in the party to whom it belongs to have the legal title transferred to him or the beneficial interest of one person whom equity regards as the real owner. So that's the bifurcated title, which means bifurcated means 2 parts. So that would be the legal title and the equitable title. Surety, a person who is primarily liable for payment of debt or performance of obligation of another. Creditor, one to whom money is due, and in ordinary acceptation has reference to financial or business transactions. The original straw man trust. On the original straw man trust, mom was the exchanger, trustor, or settler. Mom applied, or your mother applied to the state of, or whatever, for the creation of a trust. She chose the date of birth for it. She chose its name. She requested evidence that it had been created. equals birth certificate. She was the informant. She delivered the paper description of the original property to the trust creator. It was a description of the real substance. The paper description was the original trust corpus. More trust property could be added later. State of whatever was the creator of the original trust. The state complied with mom's request and created a straw man with the name and date of birth your mother requested. She applied for a social security number for it. She put it into commerce by getting it medical numbers, a daycare center matriculation number, a public school matriculation number, a little league ID number, a library card, etc., etc., etc. Sometimes the creator is also the original exchanger, trustor, or settler. Who's the beneficiary of the original trust? The beneficiary changes each time a new trust is created. You're the original beneficiary, though, if you choose to use your beneficial interest. If you choose not to use it, the citizens of the state that created it are the beneficiaries. This is part of the highest and best use principle. If the property is not being put to its highest and best use, it can be borrowed for a time and put to better use. You have not been using it. You have not filed any claims against it. So why should it just sit there not being used? This first trust was created for your benefit if you choose to use it. Remember, the reason the first party, creator, creates a trust is for the second party, trustee, to manage the trust corpus for the benefit of a third party, beneficiary. What is the trust corpus? The state complied with mom's request and created a straw man with the name and date of birth she requested. Mom is the one who put your physical description on the application for the certificate slash evidence that the trust had been created. She delivered the trust 7 pounds, 11 ounces, 19 and a half inches long, and a footprint. All of this was on paper. The paper is the trust corpus. This was the consideration that was exchanged into the original trust. Exchanged for what? The ability to gain possession, not title, of houses, cars, shoes, books, etc., without paying for them. And that's exactly what everyone's been doing because you're using Federal Reserve notes to get houses, cars, shoes, books, and etc. without paying for them because the Federal Reserve note is actually debt paper, and you can't um, pay a debt with a debt. So let's continue. She applied for a social security number for it. She put it into commerce by getting it medical records, a daycare center matriculation number, a public school matriculation number, little league ID number, a library card, etc., etc., etc. All these paper contracts between the trust agencies, between the trust and agencies of municipal corporations are trust assets. These are all part of the trust corpus, the trust property. They are all property that can be used as evidence to contractual obligations the trust has or as collateral for debts the trust owes. It appears the trust is using your description and your credit to gain assets. It has an obligation to you. Maybe these assets can be considered benefits for which you owe an obligation because of your close relationship with the trust. Or these assets can be considered collateral for the debt the trust owes you. Who is the trustee? On the private side, if an appointed trustee resigns or dies, the trust corpus reverts to the beneficiaries or back to the trustor. It is useless to create a trust without appointing a trustee. The trustee created by the state upon mom's request must also have a trustee, or the trust created by the state upon mom's request must also have a trustee. The problem is, depending on how it is going to be used, the creation of the trust is a matter of construction and operation of law. This is constructive trust. Constructive trust. Trust created by operation of law against one who, by actual or constructive fraud, by duress or by abuse or confidence, or by commission of wrong, or by any form of unconscionable conduct or other questionable means, has obtained or holds legal right to property which he should not, in equity and good conscience, hold and enjoy. Construction. Drawing conclusions respecting subjects that lie beyond the direct expression of the term. Operation of law. This term expresses the manner in which rights and sometimes liabilities devolve upon a person by the mere application to the particular transaction of the established rules of law, without the act or cooperation of the party himself. Default, an omission of that which ought to be done, specifically the omission or failure to perform a legal or contractual duty. There can be more than one trustee for a trust. One trustee may have the duty of performing certain actions of the trust. Another trustee may perform different functions. The identity of the trustee or trustees of these individual trusts is often not expressed, as there is no requirement for there even to be a written trust indenture. On the public side, there must always be a default trustee. If no one volunteers to fill the duties of the trustee, if no one volunteers to be, if no one volunteers to fulfill the duties of the trustee. When a corporation or limited liability company is created, the statutory default managing manager is the Secretary of the state where the entity is being created. In some states, the Secretary of State would be the logical default trustee. In other cases, the lack of a trustee may result in a presumption that you're the trustee. Trustees have a fiduciary duty to manage the trust honorably and for the benefit of the beneficiary. A trust may not use the trust for personal gain. A trustee that is acting outside his duty or not performing at all is in breach of his fiduciary duty. That is not tolerated on the private side or the public side. Trustees in breach of fiduciary duty are held personally responsible for the breach and take on the financial penalties for their actions, malfeasance, or lack of actions, nonfeasance. Here is an example of a court scenario where when a man participates. Investigator from ABC agency or municipal corporation has filed an information with a prosecuting attorney on the public side. Affidavits are not required. The information is not required to sign an affidavit. The information is not required to sign an affidavit submitted to the attorney to commence a public action against the individual being investigated. Affidavits were required in equity when someone wanted to file a claim in court. In admiralty, in the public, affidavits are no longer required. They have been replaced with what is called an information. An affidavit is signed under oath. The statements made in the affidavit, the statements made in an affidavit are the signer's bond. His word is his bond. The affidavit formally bonded the case. Now there are no affidavits. There are no bonds to bond cases. The prosecuting attorney has to decide whether or not to commence an action. The informant may have completed an administrative process, IRS, 90-day letter, 30-day letter, 10-day letter, for the attorney as the basis for bringing the action. And that's what's called an administrative process. So that's the administrative process of three letters. It may not have started an administrative process yet. 9 times out of 10, the administrative process is not needed because they are almost sure you will agree without knowing it to represent the accused individual, the trust, by volunteering to act as its trustee. The attorney is going to create a new trust to be the accused on the complaint or indictment. If you go into contempt for defending and not taking responsibility for the new trust, you will either pay with the trust corpus or you will go to jail and your credit exemption will be tapped during the time they are housing and feeding you and giving you medical treatment. The trust corpus might include the balance in a bank account, a title to real property or a car, or any other public asset. Creator. The attorney is the creator of the accused trust. It might be John Henry Doe. Notice that they never put your name on a complaint, indictment, or traffic ticket. Even if it is written in upper and lowercase letters, it is still a fiction and a trust. We cannot mix public and private. Trust name. The name of the trust is John Henry Doe. In the body of the complaint, a reference may be made to John Henry Doe or John Doe or John Doe. This is how the judgment can be multiplied. These might all be new trusts against which the financial judgment can be applied and for which it is presumed you will volunteer to be the trustee and through which you will be presumed to be surety. The trust is expected to be the defendant. The question is, who is the trustee and who is taking responsibility for the trust activities? Trustor. The attorney is also the trustor. He is putting the trust corpus into the trust. That is the charge. It is a debt, a liability on the public side, and a credit, asset on the private side. We have always presumed a charge is a bad thing. It is only a bad thing if the man is found in contempt of the process, or of the attorney, or of the judge, or of a number of other possibilities. It is very easy to go into contempt. If you don't agree to take responsibility, you will be in contempt of your presumed fiduciary duty. Creditors do not go into contempt. Beneficiary. The beneficiary is the state of, which is also the plaintiff in this case. It is the person that stands to gain from the charges, trust corpus, but it only has the equitable interest in the trust corpus. That way, the beneficiary does not help this that way the beneficiary is not held responsible for bringing a claim without a bond, evidence of a debt. The attorney does it instead. The beneficiary has to hold on to its creditor position and can't if it brings unfounded claims. The plaintiff seldom signs the complaint. The attorney's signature is usually the only one on it. Trustee. This is the trust position. the trust position that carries all the liability. The trustee has all the trustee has a fiduciary duty to manage this trust property for the benefit of the state of. And it does not if it does not, the trustee accepts the responsibility for the losses suffered by the beneficiary, the state. There is no appointed trustee. There is a presumption that there will be a trustee when it is needed. The attorney has the complaint served on the original trust with a name like the accused individual, the defendant trust. Someone has to represent the defendant. At this point, the only representative for the trust is its creator, the prosecuting attorney, which has made a commitment to the beneficiary. Once the charge is signed by the attorney and delivered to someone who might volunteer to be the trustee, the attorney does not even have the option of withdrawing the charge without the defendant's agreement. Rule of court. Since the complaint was delivered into your hands as the presumed trustee and surety, you have to agree to the withdrawal of the charges before they can be withdrawn. As soon as you hire a good attorney or decide to defend the trust yourself, the liability has moved from the prosecuting attorney to you. The fact that you are defending all by itself is a dishonor. Anything other than all out acceptance is a dishonor. Your dishonor is what gives the prosecuting attorney the energy to bond the case. All cases have to be bonded. Whoever bonds the case is the creditor. Whoever is in dishonor is the debtor. They need you to dishonor the process, the attorneys, or the judge to have the standard script result or the standard outcome. If you fail to immediately go into dishonor, there will be plenty of opportunities in the script for you to carry out the plot to get you into dishonor. You can plead not guilty, testify, defend, call witnesses, question witnesses, file motions, file a countersuit, answer questions, or not respond at all. Just to name a few ways to volunteer to be the trustee and to be in honor. Or to be in dishonor, actually. That's dishonor. You plead not guilty, testify, defend, call witnesses, question witnesses, file motion, file a countersuit, answer questions, or not respond at all. Just to name a few ways to volunteer to be the trustee and to be in dishonor. Your voluntary dishonor will authorize the use of your credit to bond the case. Since you did not voluntarily bond the case, you are in dishonor. Surety. Since the standard script will be used for the court event, it is likely the man who has volunteered to be the trustee for the accused trust will defend the trust. That will guarantee the standard outcome. The defendant will be found guilty and the trust corpus will be liquidated enough to pay the judgment debt. In the event, if the event involves criminal charges, the man's body will be jailed so the state can revenue the man's credit from private into the public state. This is what keeps the public machine running. Revenue. The man will be surety for the judgment debtor once the trust is found guilty. Plaintiff, state, beneficiary is the plaintiff and presumed creditor, as long as the man plays by the standard script. Defendant, the prosecuting attorney needs to have a volunteer to defend the trust, or he will be stuck representing the accused trust himself. He is a defendant, but does not plan on holding the position very long. With the help of the judge and the defense attorney, the prosecuting attorney will be able to pass the liability onto the trust and his representative and surety, you. But you have to go into dishonor for this to happen. All charges, arguments, and testimony is dangerous in the public court. Remember, it is not your court. They can only see fictions. So if you are testifying, you are recognized only as a fiction, as you are a piece of paper. But if you are talking to him, he presumes you are the trustee for the trust. In that capacity, he can talk to you. He is expecting you to breach your fiduciary duties by going into dishonor. Then they win, you lose. You want a win-win situation. Be careful even with the copyright. If you can bring the copyright into the case without testifying through third-party witnesses, which is a notary, you may be able to stave off a demand for trust property. If you're already given the right to use the now copyrighted name to a corporation, you cannot revoke it. You cannot revoke it. You cannot revoke it. You cannot revoke that authorization after the fact. You may have done that by applying for a loan. You gave them the use of the name on the application. You gave them the use of the name on the driver's license application. You are the one who tells them what name to put on the license. You can't come back later and charge them for using the name you previously gave them. If there's no driver's license application, you may be able to give notice of the copyright to the officer and then enforce the copyright violation because he had notice of your restrictions to use the name. Even if the car is registered with the state, you may be able to use the copyright in this action if you know how and do not dishonor your own claim to being the private owner of the name. And we're going to stop right here. I think it's a really good time to stop. Like I said, bear with me. There's some typographical errors that we're gonna have to get through, but this is still a very important document. And by the way, there's Yusuf L actually went over this document on High Frequency Radio. I think he did a really good presentation. I just wanted to do it over. I just wanted to do it over because it's real important to me. But yeah. And just remember, you can't make a shot you don't take. Peace and blessings. Don't you dare go testing. And I'm gonna politic with you guys later.